Great. Thank you very much, Kelly. You're definitely getting to be a pro at these introductions with the number of these that you've been doing. Hopefully you don't get too worn out on these Zoom calls. I hope that everybody is doing well, that everybody's been able to stay safe and healthy. I have Mary Beth Clark from North Penn Legal Services with me today. She's going to join us towards the end of the session to share a good case story. Again, I'm Matt Rich from Mid Penn Legal Services in the Harrisburg office. I think I presented last year, I think it was last year's VOCA trainings where I had done my first special relief for victims of domestic violence and talking about housing issues. This is, if any of you folks were present for that session last year, we were sharing that time slot with utilities and public benefits. So I had to cram about an hour's worth of stuff into 10 minutes or so. So much of this is a reprise of last year. I did try to update some things here and there where I could. Apologies if folks took a close look at that last year and had gotten the resources from that. And if any of this is repetitive, but since I didn't get to cover much of what I was hoping to cover last year, I have reprised that here. So what I want to start with is I want to start just by talking about what we're going to go over, what we're hoping to do with this session, and a couple of kind of caveats that I want to set forth up front here. First is just to talk about what I'm hoping that you folks can take away from this session, since I understand that either most or some or maybe all of you, you may not encounter housing situations or scenarios or issues much in your day-to-day practice. It might be something that comes up as an ancillary issue when you're dealing with other legal issues for your clients. I don't expect that many of you are going to take away from this like all of this vast knowledge and that you're going to know how to pull this stuff up and utilize it when need be. So what I want to try and impress upon you folks is I think that if you take anything away from this session is mostly and firstly knowing to just how to issue spot, right? So what I intend to do is talk about what I think are kind of the three major areas of contention or issues where you may see problems develop with your clients with regard to housing, which is we're going to talk about the Violence Against Women Act, VAWA, which applies to subsidized housing. We're then going to talk a little bit about market rate or private housing where VAWA does not apply and it becomes a much more difficult situation. And then also touch a little bit on nuisance and crime-free ordinances. And so, I think if you folks, as you're working with clients on the day-to-day, if you can at least just know that these things exist, know that there are these discussions to be had around subsidized housing versus private housing, and then these nuisance and crime-free ordinances you might encounter, if you can at least spot those issues, that's a good first step. From there, what I want to try to leave you folks with, even if nothing else today, is if you spot an issue with regard to housing, is to know that there is a network under the umbrella of plan. There's a housing law group, and I would suggest that you folks try to touch base with anyone from that network in the event that you have a problem that develops, if you have a case that you need to take a further or deeper dive into with regard to the housing issue, rather than you maybe having to try and figure it out all on your own. There is a Plan Housing Law Group listserv. I have the address there for you to utilize. If you do have a problem, don't be ashamed or afraid at all to reach out to try to collaborate with folks from the Housing Law Group, folks that do housing either primarily or exclusively, that can and should be able to assist you with any housing problems you encounter. I also listed here what I think is probably the best resource that I'm aware of as far as trying to track down information, materials, documents, all of the laws and the HUD regulations we're going to talk about, is the National Housing Law Project has a protections for survivors of domestic and sexual violence website or a resource center. I'm sorry, I have the website listed there for you. That's a good link. Honestly, the vast majority of the stuff that I have in the presentation today was taken from that resource center, that website. And then they also have a partner website with that. They have a nuisance and crime-free ordinance initiative that's just a separate site and resource center as well. And then the last thing we're going to hit on, as I previously mentioned, is I'm going to have Mary Beth come in and talk about an example of a good case, which highlights the collaborative efforts of Mary Beth and myself and some others in the housing law group to try to work on solving problems in the areas of housing areas for victims of domestic violence. So I'm going to jump right in, start with VAWA. I want to first focus on the historical background and then the current status, because there is a little bit of question that pops up there with regard to the background and then ultimately where it stands at the moment. I will apologize for my dog in the background. It's the joys of working at home. So Congress passed the original VAWA back in '94 as part of the Violent Crime Control Law Enforcement Act. The protections afforded by the '94 version were subsequently then expanded and improved and included in the VAWA of 2000 and Reauthorization Act of 2005. What VAWA is it's a law that protects victims and threatened victims of domestic violence, dating violence, sexual assault, and stalking from being discriminated against by certain housing providers. And again, certain housing providers is the big thing. Only subsidized housing providers are going to fall under the umbrella of VAWA because of the abuse that's been committed against them. And we're going to see then, I think I'll touch on in a minute, that this comes into the context of applying for housing, and then also for a situation where somebody's in housing and they're being threatened with eviction from housing. Now, most recent iteration of VAWA, it was passed the Reauthorization Act for VAWA in 2013. I have the site there for you. That reauthorized most VAWA programs under that authorization it reauthorized most of the VAWA programs until the authorization for the grant programs expired on December 22nd of 2018. Now, where there is confusion as to the current status is that although the congressional authorization for the grant programs expired at the end of 2018, VAWA 2013's housing protections do not have sunset provisions, and thus they did not expire when the authorization for the other grant programs expired back at the end of 2018. So as of right now, VAWA's statutory housing provisions, any related implementing regulations from HUD, any and all related HUD guidance, all of that therefore remains in effect. That is one of the areas of confusion. Like we see this often on the National Housing Law Project also has a listserv for housing providers and housing advocates throughout the country. And every so often, since end of 2018, we've seen these questions arise where somebody will say, hey, I was talking with my local housing authority, or was talking with a Section 8 landlord, and they said they had read somewhere that VAWA ended in 2018 and therefore they don't have to follow VAWA. That is a misconception that is relatively, understandable, I imagine, but is definitely misguided. And there is a template letter that the NHLP put together on the website and the resource center that I linked to earlier, that talks about the expiration of the congressional authorization, but the continued existence of the housing protections. There's a good template letter there if the need arises that could be utilized to send to a housing provider if needed, if that issue comes up. But that's the one kind of key thing to know about the current status, is that all the housing protections are still in play. So we want to talk generally about how VAWA applies. So I have the housing statute cited there. I have the portions of the Code of Federal Regulations, which have the applicability, the definitions, the protections, et cetera. I'm going to break out some of those here over the next couple of slides. But just know that VAWA provides these housing protections for survivors of DV, sexual assault, dating violence, stalking, for those who are in federally assisted housing. So again, does not necessarily apply to the market rate or private rental unless there's a federal subsidy involved, which I'll touch on in a second. The law applies to a survivor, whether it's actual or perceived, regardless of sex, gender identity, sexual orientation, disability, or age, and also to all lawful household members as well. The overwhelming majority of domestic violence victims are female. However, VAWA protections are gender neutral as they're written, and therefore they do apply equally to both men and women who are victims of domestic violence, dating violence, and stalking. And we'll come back to the idea or the notion that, or not the notion, but the fact that the overwhelming majority of victims are female when we talk about the private housing context and how that might come into play to be, the statistics may come into play to support some arguments there. Continuing on with the general applicability, I've listed out that the federal housing programs to which VAWA applies. I highlighted in red the programs that I think you're likely to encounter most frequently. Certainly all of these other programs fall under the umbrella of VAWA, but I think most likely you're going to encounter either a public housing situation where you're dealing with a housing authority and what are known as project housing or public housing. The Section 8 Housing Choice Voucher Program. So for any folks that might be unfamiliar, in a nutshell, Section 8 Housing Choice Voucher is where the government, through a local housing authority, issues a housing choice voucher, which is a voucher that the tenant can put in his or her pocket and can then go out into the community and rent private housing from a private landlord. There are certainly a bunch of parameters there that they have to work within the confines of, but essentially it sets up a triangle between the housing authority, the tenant, and then the private landlord. In that scenario, right, so even though that's a private landlord, because that private landlord is receiving the federal subsidy through the Section 8 voucher, that private landlord is covered. So that's a situation where if you do identify that the person has a Section 8 voucher, even though they're dealing with a private landlord and even though it might look otherwise as though VAWA wouldn't apply, if we're aware that there's that Section 8 voucher in play, that does pull us under the protections of VAWA. You have project-based Section 8, which are units that are owned and operated typically by private companies, private conglomerates, but they have a line with HUD to receive funding from HUD, and therefore either the majority of or perhaps all of the units in any one of those complexes is subsidized the same way as public housing or the Section 8 voucher program. It's just administered a bit differently in that you deal directly with the owner of that property. And then down below, I also highlight on a different program through the Department of the Treasury. So instead of being through the Department of Housing and Urban Development and HUD, through the Department of Treasury and the IRS is the Low Income Housing Tax Credit Program, or LIHTC. That is now, as I understand it, LIHTC is now the largest stock of subsidized housing in America. It's surpassed public housing and the voucher program and project-based Section 8 to now be the largest sector of subsidized housing. It's not, because it is run through the IRS and it's through the Treasury, it is operated differently than HUD subsidized housing. In HUD subsidized housing, that's what we consider to be we call deep subsidies, where folks that either live in public housing or have a voucher or live in project-based Section 8, their rent is based on their income at any given time in any given month, and it's always roughly around 33% of their income. LIHTC operates a bit differently in that they look at different factors to determine what the monthly rent's going to be for the subsidized portion of their property, or if the whole property is subsidized for the whole property. But they set a flat rent amount. That rent is not dictated by the tenant's income at any given time. So the rent in LIHTC doesn't necessarily go up and down. It stays flat, but it is lower than market rent. We call that more of a shallow subsidy as opposed to the deep subsidy that's offered through the HUD programs. But these are all covered by VAWA. If you identify that you're working with a client who's a tenant in anyone that's subject to any one of these programs, VAWA does apply and is in play, and the protections are in play. So under VAWA, survivors who apply for or participate in any one of these covered housing programs, they have the following rights, amongst others. So number one, not to be denied admission, not to be evicted, not to have any assistance terminated because of an act of violence committed against them. So for example, a housing provider cannot deny an applicant housing assistance because of a history of domestic violence or sexual assault, stalking, or dating violence, including if the survivor has a criminal history or poor credit history, which is directly related to the violence. A survivor has the right to be provided a notice of their housing rights under VAWA. There's a form that HUD prescribes with all of the victims' housing rights on it, and that form, that HUD form 5380, is required to be provided to all tenants. You might even, I've seen certain situations where VAWA is not implicated, but any new tenant receives that form anyway. Also, there is a VAWA self-certification form, which I'll talk about a bit later as well, HUD 5382. That has to be provided by the housing provider to the victim or survivor when they're admitted into the program, or if they're denied admission or assistance, or if they receive an eviction notice or a termination notice. So again, even in situations where the person might not be a survivor or a victim, the housing provider is required to provide these notices anyway. And so they're going to be given across the board. And so if you do encounter a situation where a person is being threatened with eviction or they're being denied housing, just know that there's this form that prescribes all of their rights. There's also a separate form that they can complete to self-certify their status as a victim or a survivor. That should go a long way towards helping them with whatever the issue is with the housing provider. The victim or survivor has the right to request that an abuser be removed from a lease and housing where it's applicable. Now, mind you, again, keep in mind, we're talking about subsidized housing. It operates a little bit differently in the private housing context, which we'll talk about. But if we have a situation where they're living in public housing and it's the spouse and them are on the lease and the spouse abuses them and the spouse is removed through a PFA, the victim has the right to follow up with the housing authority to request that the abuser be removed from the lease permanently, dependent and exclusive of the result of the PFA. For participants with a housing choice voucher, right, so where they are renting from a private landlord, they have the right to request a move with continued assistance if they're looking to flee from their abuser. They have the ability to request a transfer or a move. If they're in like public housing, say, or site-based Section 8, they have the right to request a transfer, perhaps to a different unit or a different complex, depending on the circumstances. And when the housing choice voucher situation, they have the ability to get a new voucher to be able to utilize that to move. Whereas otherwise, they might be required to live out the full term of the lease, and they wouldn't be allowed to get a voucher and move. They are able to request that in a situation where there is domestic violence present. So continuing on with the rights of VAWA victims and survivors, they have the right to seek an emergency transfer, like I was just talking about, to another unit in the same program or under some other federally subsidized housing program. And one thing I'll say that I will encourage you folks, if you are encountering a housing situation, is that obviously there are certain parameters we have to operate under, but with a lot of housing situations, like the story that we're going to get into with Mary Beth, where she tells you about her client story later, I think that there's a lot of room for creativity in trying to solve problems. So like I've had situations in the past where there's been an issue, maybe not domestic violence related, but there's just been an issue generally where, say, a tenant is not getting along with their neighbor for one reason or another, and maybe the housing authority is willing to work with my tenant, but they just can't have that tenant remain in the same unit. I've gotten creative in the past where I've asked for a transfer to another unit in the complex, or I've even had situations where, say, they're in public housing and I've gotten the housing authority to agree to transfer them over to the Section 8 program, so that instead of them transferring to a different public housing unit, they could transfer into the Section 8 program and they could go out into the community and they could try to find their own place. Now, again, there are certain constraints on that, of course, but I would suggest that if you run into one of these situations, don't hesitate to try to be creative and working with the housing provider to try to come up with a creative solution. The victim or survivor has the right to stay in the unit, even if there is present or there has been criminal activity that's directly related to the violence, right? So if the abuser comes, say that whether the abuser lives with them or doesn't live with them, if there is abuse that happens in the unit, if the tenant, the victim, the survivor, if they want to remain in the unit, they have the right to remain in the unit. And whereas the housing authority might otherwise try to evict somebody because of any criminal activity associated with that unit, they would not be able to do so if the victim or survivor can prove that the criminal activity is directly related to the violence. And that's where the self-certification form comes in. They have the right to strict confidentiality of information about their domestic violence, including their status as a victim. This information can only be shared if it's requested by the survivor in writing for a time-limited disclosure. If it's requested for use in an eviction proceeding or required for use in an eviction proceeding, or is otherwise required by law. Generally speaking, they have strict confidentiality rights. They have the right to self-certify, as we've been talking about that, HUD 5382. It's available in at least 11 different languages. So if language is an issue, that form's available in many different languages. If there is conflicting information between what the victim or survivor provides in their self-certification form and what the housing authority derives from other means, like maybe talking with the abuser or looking at public records, the provider may request additional documentation from the survivor beyond just simply the self-certification form.
Matt, if I can interrupt you, excuse me, if I can interrupt you just for a second. I just launched the first of the poll boxes for the CLE credits for attorneys. Feel free to answer if you're not an attorney. However, I just need this to sorry, it shut down on me for some reason. So please go ahead and respond if you're an attorney requesting CLE credit for your participation in this webinar. This is the first of 2 polls, and I will leave it up for a minute. Thanks, Matt. You're free to go ahead.
Now, if I minimize this, I hope that doesn't, I'm going to minimize it. Hopefully that doesn't do anything. Okay.
You can just click it off your screen.
Got it. Okay. So certain limitations. Oh, sorry. Go ahead. Okay, you're good. Okay.
No, I just said
right, so
thanks.
Got it. Thank you. There are certain limitations to VAWA, right? So housing, it isn't necessarily open-ended. Housing providers can still evict or terminate assistance for violations that are not related to VAWA reasons, right? So if there is a non-payment of rent situation and the victim or the survivor cannot prove that it's related to domestic violence, then the housing authority would still be able to proceed. Although what I would submit to you is that, again, when we talk about getting creative, I mean, if there's any way at all that you think you can tie an issue to domestic violence, I would submit that you should try it out and let the housing authority be the one to tell you that they're not going to work with you on that. Because I think by and large, housing providers, at least the ones that know what they're doing and they know what VAWA is and how it applies, they're generally pretty sensitive to VAWA-related issues. So to the extent that you fill out a self-certification form, as long as it has in there what they feel that they need for their purposes to be able to cover themselves in case there's some sort of issue when they get audited, they're usually pretty willing to work with you. But just know that it isn't, that it isn't limitless. The housing provider also can still evict the assistance or evict or terminate the assistance of a survivor if they can show that by not doing so, there would be an actual and an imminent threat to others, or like other tenants or to staff who work at the property. So for instance, but in that case, I mean, when I say actual or imminent, it means there's a pretty high burden there for the housing provider to carry. The landlord has to be able to show that it actually poses a physical danger that's real and not just a perceived danger, that it would occur within an immediate time frame and not just something that could happen at any time in the future. And it has to show that it could result in death or serious bodily harm. So it can't be just economic damage to the property. So importantly, HUD has emphasized in their guidance that this exception must be used as only a last resort after the provider, the landlord, has explored alternatives that would keep the tenant and the staff safe while maintaining that housing assistance. So again, they're pretty in tune with this, and there's a pretty high burden that they have to meet to be able to move forward on that imminent or actual threat exception. Okay, so now forms to know. I had mentioned some of these earlier, right? So we talked about the HUD 5380, the notice of the occupancy rights. I've already gone through some of it, but I don't want to spend too much time. It's all outlined there as far as what all is in that form, all the information that's provided to folks as they apply or if they're being terminated. HUD 5381 is the model emergency transfer plan for victims of domestic violence. So if you're working with a housing provider that is maybe interested in working with you but might not have a plan set up or doesn't really know how to go about it, there's a model plan that you can turn to for an example and for ideas. HUD 5382 we talked about, which is the self-certification form, which is simply, it's in the form of an affidavit. I hadn't looked at it. It's probably my bad. I forget if it has to be, I think we had it notarized. I can't remember if it has to be notarized or not. But if you check out the form, you'll see that it's just in the form of an affidavit where, your client, the tenant, just simply goes through and explains the timeline of events, what happened to them. VAWA does not require for there to be a PFA to have been filed in order for the protections to apply. So if you fill out the if you don't have a PFA, if the victim didn't feel comfortable filing, but there is still this violence present, that's where the self-certification form comes in, where they can simply outline the abuse, and they don't necessarily have to be able to document it, again, unless there is some conflicting information that the housing authority or the housing provider unearths and comes back and requires the victim to provide any additional information or documentation. And then 5383 is an emergency transfer request that can be utilized in conjunction with the 5381 model emergency transfer plan. Now, that covers the subsidized housing aspect, right? So you've got VAWA in play, but again, I think one of the maybe misunderstandings with related to VAWA is that it does not apply to private housing, to market rate housing. So if you're dealing with a situation where you have just a regular old private landlord-tenant situation, we don't have the protections of VAWA there, and it does get a bit tricky there. There's, generally speaking, those are difficult situations to try to handle, right? If you have, and especially, I know the one scenario I can put out to you that I know is the most troubling that I've encountered is the situation where you have the victim who is living with the abuser. The abuser is the only person on the lease with the landlord. The victim was not on the lease, and then the victim files the PFA. The abuser is then removed from the home pursuant to the PFA, subsequent to the PFA. And now you have a situation where the landlord may be partial to the abuser because, if they were friendly as landlord and tenant, they might be friendly to the abuser. And I've had to deal with those situations where the landlord's trying to do whatever it is that they can do to get rid of the victim, either because they don't have a lease agreement with the victim or because, again, if they are friendly with the tenant, it might be as retribution. And those are difficult situations where your client does not necessarily have a legal right to remain in the property because there is no privity of contract or lease agreement with the owner of the property. Those are difficult to deal with for sure. And those are the ones where, like I said, I would suggest if you run into one of those, reach out to somebody in the plan network that does housing, reach out to the listserv for some ideas on that. But what I want to mention here as the kind of the protection, so to speak, that's available with regard to private housing is the Fair Housing Act, right? So some folks might be familiar with that, even if you don't do housing. And generally speaking, Fair Housing Act is an act that applies broadly to almost all market rate or private housing. There are a few exceptions, but generally speaking, the Fair Housing Act is in play for the vast majority of private housing situations. And the current statute makes it illegal for a landlord to discriminate on the basis of race, color, religion, sex. You'll see I've emboldened and I've underlined there, familial status, disability, and or national origin in the sale or rental of housing. So I highlight sex there because while a person's status as a domestic violence survivor or victim is not in and of itself a protected class, there are arguments available that can be made and claims that have been made successfully in certain states where you can tie domestic violence to sex discrimination because of the statistical analysis and the reality that the majority of domestic violence victims are women, and women are much more likely than men to be victimized by an intimate partner. And so where this ultimately then ties into is intentional discrimination through disparate treatment or disparate impact. And that's, again, I have there's a fair housing toolkit that the NHLP put together that is on the page that I had linked to earlier on, where it has a collection of all the different cases where the victims advocates have argued that the Fair Housing Act should apply, that it would be sex discrimination for a landlord to evict or to not accept an application on behalf of a victim of domestic violence, even in private housing, because it would equate to a violation of the Fair Housing Act. So it's not anything that I've ever utilized myself personally, but there are cases out there where it has been successful. And so even though the market rate of private housing scenario is a difficult one, it's not that we're without options. Even though we don't have VAWA, just think or note that the Fair Housing Act may come into play and may be utilized. Nuisance and crime-free ordinances, right? So this is another kind of area where we run into problems in this intersection of housing and domestic violence. So nuisance ordinances take several different forms, may also be called like disorderly or disruptive housing laws. They can take the form of fines against the tenant and/or they can take the form of requiring landlords or property owners to evict a tenant, or the landlord or the property owner would face losing a rental license. These are ordinances that are enacted usually by local municipalities, and they apply to rental housing in that municipality or that community, that city, whatever the case might be. All of them have to have at least one thing in common, though, right? When you look at these, when applied, these ordinances are going to put victims of domestic violence at a grave risk of harm, either by requiring that the victim be evicted from stable housing or by deterring the victim from accessing the police protection when they need. So I highlight the Briggs versus Norristown case, which is one of the bigger cases, frankly, nationally in this area. I think it's one of the more recent ones as well. I believe it was 6 or so years ago. Don't quote me on that. And this is a case involving the PA ACLU, the ACLU Women's Rights Project, the Pennsylvania Coalition Against Domestic Violence also filed an amicus brief and assisted in this case. Essentially what it was is you had a local 3 strikes ordinance which threatened the loss of police protection for an eviction of a domestic violence victim who contacted the police more than 3 times within a certain time frame. And so the end result was that, and this was, the facts of the case were pretty gruesome, where this woman, Miss Briggs, was routinely abused and pretty significantly so. And the police got to a point where they, if I'm not mistaken, either said they were not going to respond to any more calls because they viewed it as being a nuisance, or, and maybe and/or, they had turned to the landlord and were trying to require the landlord to evict Miss Briggs for being a, quote, nuisance. And so through that litigation, the end result was a HUD conciliation agreement reached, wherein, amongst other things, the ordinance was repealed, and then damages were paid by Norristown to Miss Briggs as a result of that. And there have been other similar cases that have been brought throughout the country to try to strike down these nuisance ordinances because of their disparate impact on victims of domestic violence. I have there the act in the Pennsylvania law that applies for protections for domestic violence victims against penalties which are imposed by such ordinances. Again, something to think about if you run into a situation where you have a client telling you that they're being told by their landlord that, and that's, may very well be the case. The landlord might say, hey, I don't have a problem with you, but my hand is being forced. The municipality, the city, they're telling me that if I don't evict you, I'm going to lose my rental license, and I can't afford to lose my rental license, so I've got to evict you even though I like you and I understand your situation. You might even have a sympathetic landlord situation where it becomes an issue of trying to attack the nuisance or the crime-free ordinance. So I am now going to cede the floor, because you've all listened to me drone on. I'm going to cede the floor now to Mary Beth Clark to have her talk about a good case example. She's going to walk us through. I have outlined here some of the key points, but I'm going to let Mary Beth take it from the start and walk us through the case that she had worked last year. Mary Beth?
This is Kelly again. If you don't mind, I'm going to launch the second poll for CLE credits. Please respond if you're an attorney requesting CLE credits for your participation. The poll box will stay up for 1 minute. And Mary Beth, you're free to go on.
I'm going to mute myself, Mary Beth, and then you just have to unmute Mary Beth. I'll mute mine.
Good morning. I'm here today because this time last year I was in attendance like many of you, and afterwards I spoke to Matt about my case, and we collaborated along with another legal aid attorney, and together they really helped me think beyond the usual and broaden my view of what was possible to really get what was the right result for my client. So let me tell you a little bit about the case. The tenants were a husband and wife, and they rented a house from the landlord. A year later, my client, who was the wife of the tenants, was the victim of a horrific act of domestic violence by her husband at the house, which act was tape recorded during a 911 call by my client. During the call, she shot her husband in self-defense with a pellet gun, and he died. She was immediately jailed and criminally charged, and the landlord knew she was in jail, as it was in all the news outlets. From jail, my client asked family and friends to go to the house and get her belongings. Landlord prevented them from entering the property with threats of arrest for trespass. Landlord then filed an eviction action in magisterial district court. The tenant was given notice in jail and requested to attend, but it was scheduled for the same day as a hearing on her criminal charges. So without the tenant being present, the landlord obtained a judgment for possession and money damages. Ultimately, 6 months later, my client was released from jail, and her actions were ruled to be self-defense, and the criminal charges were dismissed. So about 8 months after the eviction, tenant sought assistance from North Penn Legal Aid to obtain her personal belongings. Our legal position was pretty clear. Landlord took affirmative actions to prevent this tenant's family and friends from taking possession of her things prior to her being evicted, which amounted to conversion of her property. So we went to the landlord and made him aware that we intended to pursue affirmative claims for conversion. And we also raised defenses to the landlord-tenant action, such as his failure to credit a security deposit. Fortunately, landlord agreed to settle. And we entered into a settlement agreement where he would return the possessions he still had. But what was most important to me for the client was that the landlord agreed to withdraw the judgment so that there was no record of any claim against the tenant for unpaid rent. Why was this so important? My client will likely be in the landlord-tenant relationship for the rest of her life. And to have an improper landlord-tenant judgment out there against her would be an impediment to her getting housing in the future. And that was just not acceptable. We know landlords use the UJS system to do judgment searches and refuse to rent to individuals who have such judgments. So landlord's attorney prepared a notice of settlement withdrawal of judgment and filed it in the magisterial district court, which they accepted and they marked received. But then nothing happened. I kept checking the Pennsylvania UJS online portal, and the judgment was still there. Informally, the staff at the magisterial district court told me the problem from their perspective was there wasn't a drop-down entry on the state's computerized system that would allow them to input a withdrawal once a judgment was entered. And so they could do nothing. Officially, what they sent me was a notice saying that once judgment is entered, it cannot be dismissed or withdrawn, and the only action is an entry of satisfaction. And satisfaction of judgment was not acceptable. I mean, to accept that would have implied in my mind that the judgment was proper. And you know, I continued to want no impediment for the client to obtain housing in the future. I did go to the Administrative Office of the U.S. Courts since the MDJ's office had reached out to them. And fortunately, I found senior counsel there, David Price, who was incredibly helpful through this process. His response to me is he thought my next step needed to be a nunc-pro-tunc appeal, which is an appeal that's out of time. It was right about this point that I was at this conference, and I talked to Matt, and Matt was great. He agreed, you know, he listened. He then agreed that I had to do the procedural wrangling of seeking leave to file a nunc-pro-tunc appeal, because I had to get permission from the court to file a late appeal. But we still had no idea how to wipe off this footprint of the case from the UJS system. Matt, in turn, joined Dan Vitek from Community Justice Project, who also sits on the Minor Court Rules Committee, into our discussion. And Matt and Dan worked with me, and we determined, you know, a roadmap for me as to where to go next. They provided me forms of pleading. If I had questions, they got back to me. So we decided that I needed to get an appeal filed, and I needed to file a petition to seal the record in the landlord-tenant action. But we didn't know if that would actually be accepted. And Dan offered as much as to go to the office, administrative office of the courts, and request they comply with an order to seal if I could get one. Fortunately for us, the Landlord's Council at this point raised no objections and was willing to work with us by consenting to the following steps. So we went to the Court of Common Pleas with a motion for leave to file an appeal nunc-pro-tunc, and that was granted. We then filed the traditional notice of appeal from an MDJ action. At this point, Matt suggested, rather than go through the steps of getting a judgment non-pros, which requires notice and then waiting, that we go to the landlord, and he agreed to a stipulation of settlement. And that stipulation of settlement awarded us a judgment non-pros and a judgment that the MDJ would have to seal the landlord-tenant action. The Court of Common Pleas granted that. And then the next hurdle we had is the prothonotary had no idea what to do. We served the order on the magisterial district judge, and I went back to the administrative office because Dan had really encouraged me to work with them. And my contact there got back to me, said that the MDJ had contacted them about the case, and he did not expect any issues. And much to our great surprise and joy, a week later, all evidence of my client's landlord-tenant judgment was gone. There was no footprint of that judgment, and we got her the right result. And this never would have happened had I not asked for help, had Matt not jumped in and brought Dan into the discussion, and had we not worked together. I think the collaboration and the creative thinking is what got this client a just result. So thanks, Matt, for letting me tell that case.
And thank you for sharing, Mary Beth. I just, you know, again, I get like chills, honestly, like just hearing you talk about that, frankly, because that was it was just such, I mean, it was not a good situation for her coming in, but I think it was great that we were able to work together to get that result. A couple of things I wanted to add on to what you were saying, and really kind of hammer home this point to everybody on the call. Number one, understand that in the landlord-tenant context, the unified judicial system is now to the point where it's operating akin to a criminal record for individuals in the context of housing. So one thing that we're always leery of now, more so than before, I mean, you know, when I first started maybe 12 years ago, very few folks knew exactly what UJS was or how to get on there, how to search it. But now we're at the point with, you know, even mom and pop landlords, but especially bigger landlords that utilize third-party screening agencies. They're very familiar with UJS. They search it all the time. And in many cases, they don't look beyond the basics of the case. They don't care what the outcomes were. There are plenty of instances where they just simply see a person's name in the system, and that works as a negative mark against them. And what I will say about that is that we do not have a process in the civil realm with landlord-tenant in particular, but just civil cases in general. There is no process akin to the expungement process or the pardon process through the criminal action. So whereas we've now, we've been hearing lately about clean slate and removing and expunging records for criminal cases and the like from UJS, we don't have a similar system. So Dan Vitek had been, since he'd been on the Rules Committee, that one of his goals was to try to figure out a way to do that. It's pretty clear that it's unlikely that anytime soon we're going to get, at least from a system-wide perspective, that we're going to get anybody to agree to implement an expungement process in civil cases. But what we had taken to do, and Mary Beth's case ended up being the seminal case now, where we had taken to try to get creative to see if there were ways that we could figure out how to essentially expunge them ourselves. And so now, through Mary Beth's assistance and advocacy and working with us, we now have this process that we can use as a roadmap to maybe try to follow if that becomes an issue in the future. Another thing that I wanted to mention with regard to what Mary Beth was talking about again is the notion of the teamwork, right? I want to try and hammer this home as much as I can. I know I led with it, I know I've mentioned it, and I want to really hammer home again here at the end is just knowing that you have advocates that you can reach out to under the umbrella that are going to be willing to try to assist you if you have questions or problems and you maybe don't know where to turn on your own. Please tap into the plan resources there with regard to housing, and hopefully we can. We're all on the same team, right? We're all a big team, which is one of the most important things for me as being an advocate under the plan umbrella is knowing that not only just within our own offices and our own programs, but just statewide, and then to a certain extent even nationally, we're all on the same team trying to help folks. So now. I'm going to end here with just kind of highlighting some resources again. There's a PCADV toolkit, which again, for any folks that want, all these resources were provided last year as well. There's PCADV toolkit that they put together in 2013, much of which I think is still good. There might be a couple of things in there that the laws might have changed and might be affected, but by and large, the toolkit's still a good toolkit. The aforementioned NHLP websites, the HUD notices that I referenced there, which are the HUD notices that went out to all subsidized housing providers with regard to VAWA and VAWA issues. They have, they're lengthy notices. I forget, they're 30, 40, 50 pages maybe each. But those are real, if you're dealing with a VAWA situation, those are go-to notices to pull up because they have scenarios outlined in there. All of the guidance is in there, and even though it doesn't have the authority of law in the context of housing, those HUD notices and the HUD guidance can be thrown at the housing provider and are weighty and do carry a lot of weight there. Congressional research memos that have been put out about the historical overview, and then also a more recent one about domestic violence in the context of COVID-19. I guess something I'll hit on real quick to just finalize. I didn't really go into the COVID-19 related stuff just because I wanted to hit on some of just the basic key points of DV and housing, as opposed to the special topic of COVID-19. But just, I'm sure I don't have to tell you folks that, one of the major concerns statistically is that there will be a rise in domestic violence as a result of the stay-at-home orders. And therefore there will be, these kind of COVID-19 related issues that are going to come up in the context of housing and evictions and all those things that we talked about. One thing I hadn't mentioned is something called the CARES Act. If you're familiar with the CARES Act by now, that gave us the stimulus money. The CARES Act also did have a provision in there about evictions. So just very briefly, without getting too much into the weeds on that, just know that in addition to all of the VAWA protections for any subsidized housing providers, like that whole list of the VAWA subsidized housing providers, and then even for private housing, where it's privately owned and operated with no federal subsidy involved at all, if the private housing owner has a federally backed mortgage, they fall under the protections of the CARES Act. And just basically what that means is there is an eviction moratorium under the CARES Act that took hold on March 27th when it was signed into law, and that extends until July 25th. And even after that, there has to be a 30-day notice provided. So then it really, no cases are going to be filed where the CARES Act comes into play until the end of August. So just know that there is that additional protection under the CARES Act. If you're not able to, if you do have something that comes up in the very near future here, that will be in play here for the next, month and a half, 2 months or so, maybe even a little bit more, a little bit longer than that. So just know that that is available. And again, if you do run into something, reach out to folks and we can, whether it's me or others, we can talk more with you about the CARES Act protections. I have my contact information listed here. I had tried to check there. I think we had at least a couple of questions, Kelly. So I'm at the point now where I will open it up to questions, and hopefully we can answer some questions here before our time expires.
Sure. Anyone, if you have any questions that you'd like to ask, please type them in now. I'll go ahead and read. Excuse me. The first one, in my cases, landlords have used a lease violation notice if the offender was not permitted into the premises, such as they had a no admit list. In other words, if the victim reports the violence, they're in a catch-22 for admitting the offender in the first place.
Yes. So I'll unpack kind of two parts. I mean, one is that this is certainly a common issue that does arise with domestic violence related cases. Generally speaking, right, so in the context of housing, whether it be private housing, subsidized housing, any given tenant has the right to guests, to have guests and visitors. And generally speaking, housing providers are not entitled to just summarily ban types of guests, or certainly not ban guests altogether. You do run into situations where the housing provider might have a no trespass list or a ban list, especially if the person is someone that's known to them to have committed violence or criminal activity on the property in the past, or if they're identified perhaps as being someone with a lengthy criminal record. In those cases, right, so that's a situation where, again, to me, when you look at the context of VAWA and the utilization of the self-certification form, even if you are in that catch-22 scenario, right, where, the victim may have let a person back in that they know was not supposed to be in there, if you can somehow or another tie that to the domestic violence, right, I mean, if that's just, a continued result of the domestic violence, right, if the person was, emotionally, abusing them, and that led to the person allowing them back in, right, again, I think that's a situation where you can use the self-certification form to try to see how far you can stretch the bounds of VAWA and the protections of VAWA with the housing providers. Right now, if it's a situation where it's a pretty clear-cut violation, right, then you may run into a situation where, in that scenario, the landlord may be able to evict and get around VAWA by utilizing one of those exceptions. But again, generally speaking, in these, unless it was really clear that my client knew that they couldn't do what they did, and they did it anyway, if there was any way that we could try to tie it to the abuse, we can use the self-certification form to try to get around that problem.
Okay, the next is just a comment, I think, about Mary Beth's case that you all worked on. Truly amazing lawyering. And then I thought there was a bill to protect victims in private landlord-tenant cases, but that died in the House of Reps several years ago.
Yeah, I'm not familiar with that. There may very well have been. I'm not familiar with it offhand, but there may very well have been. But at this point, as we're sitting here talking right now, I'm not aware of anything that's in the works or anything that has passed. So, unfortunately, we are without any additional protections beyond what we discussed about the Fair Housing Act.
And there's no other questions coming in that I've seen. So unless either of you have anything else, we will go ahead and say goodbye. for this
We'll
week.
say goodbye. Thank you, Kelly, for putting this together. Thank you, Plan, for giving us this opportunity to share this information. Thank you, Mary Beth, for joining me. I just loved hearing the story, and I could have that repeated to me, I think, once a week. And again, where I'll leave it with you folks, again, you have my information, you have the listserv information. Feel free to follow up if you do have any questions that pop up, or if you do have any cases that you encounter and need some assistance, feel free to follow up with me or the listserv.
Thank you.
Thank you so much, everyone. Have a great weekend.
Take care.
Thanks. Take care.
You too. Bye.